Hello everyone, welcome to the channel Scientellectual. In the current video, we are discussing four sections, section 50, 51, 52 and 53 under Indian Patents Act 1970. These sections come under chapter 8, Grant of Patents and Rights Conferred thereby. First, we are discussing section 50, Rights of Co-Owners of Patents. Subsection 1 says, when a patent is granted to two or more persons, then each of them, until and unless there is any agreement in contrary, they will be having equal and undivided share in the patent. Subsection 2, it says that, subject to the provisions under section 51, when two or more persons are registered as grantee or proprietor of patent, then each of them shall be entitled to have rights as per section 48. If there is any agreement contrary to that, then the case will be different, or else everyone will have same right. Subsection 3 under section 50. Subject to the provisions under section 51, when two or more persons are registered as grantee or proprietor of the patent, then a license under the patent shall not be granted or share in the patent shall not be assigned by one of those persons except with the consent of all the persons. That is, whoever is registered as grantee or proprietor of the patent, all needs to give consent to give license or share of the patent. Subsection 4. Where a patented article is sold by one of two or more persons registered as grantee or proprietor of the patent, the purchaser or any person claiming through him shall be entitled to deal with the article in the same manner as if the article has been sold by sole patentee. Subsection 5 under section 50. The rules of law applicable to the ownership and devolution of movable property shall apply in relation to the patents also, and nothing contained in subsection 1 or 2 shall affect the mutual rights or obligations of trustees or legal representatives of deceased person or their rights or obligations. Subsection 6. Nothing in this section shall affect the right of assignees of a partial interest in a patent created before the commencement of this Act. Let's discuss section 51, Power of Controller to give directions to co-owners. Subsection 1 says, when two or more persons are registered as grantee or proprietor of a patent, the controller, if he thinks fit, will give directions in accordance with the application as to the sale or lease of the patent or any interest, or the grant of license under the patent, or the exercise of any right under section 50, upon application made to him in prescribed manner by any of those persons. The relevant rule and forms are Rule 76, which says an application for direction under section 51 subsection 1 should be made in form 11 and shall be accompanied by a statement setting out the facts upon which the applicant relies. A copy of the application and of the statement shall be sent by the controller to every other person registered as grantee or proprietor of the patent. Section 51, subsection 2. If any person registered as grantee or proprietor of a patent fails to execute any instrument or to do any other thing required for the carrying out of any direction given under this section, within 14 days after being requested in writing to do so by any other person registered, the controller may give direction empowering any person to execute that instrument or to do that thing in the name or on behalf of the person in default. The other such person should apply to the controller in prescribed manner. That is, when two or more persons are registered as grantee or proprietor of the patent and any one of them fails to execute the controller's decision or the directions, then that person becomes the person in default. Now that person will be requested in writing by the other registered persons, and within 14 days, still if he does not carry out the direction given by the controller, then the other registered person will apply to the controller through relevant form to execute that direction. And if controller thinks fit, he will empower the other person to execute the instrument or to do that thing in the name of the or on behalf of the person in default. Relevant rule and form. Rule is 77. An application for direction under section 51 subsection 2 should be made in form 11 and shall be accompanied by a statement setting out the facts upon which the applicant relies. A copy of the application and statement shall be sent by the controller to the person in default. Section 51, subsection 3. Before giving any direction under this section, the controller will call for a hearing in case of application under subsection 1 to the persons registered as grantee or proprietor of the patent, and in case of subsection 2 to the person in default. Subsection 4. No direction shall be given under this section so as to affect the mutual rights or obligations of trustees or legal representative of deceased person or of their rights or obligations, or which is inconsistent with the terms of any agreement between the persons registered as grantee or proprietor of the patent. Relevant rule is Rule 78. The procedure specified in Rule 55A and 57-63 relating to the filing of notice of opposition, written statement, reply statement, leaving evidence, hearing, cost, etc. shall apply to the hearing of an application under section 51. Let's discuss section 52, grant of patent to true and first inventor where it has been obtained by another in fraud of him. Subsection 1. When a patent has been revoked under section 64 on the ground that the patent has been wrongfully obtained and in contravention to the rights of petitioner or any person under or through whom he claims, or where in a petition for revocation the appellate board or court, instead of revoking the patent, directs to amend the complete specification by excluding the claims in consequence of finding that the invention covered by such claims has been obtained from the petitioner. The appellate board or court may, by order passed in the same proceeding, permit the grant to the petitioner of the whole or part of the invention which the appellate board or court finds has been wrongfully obtained by the patentee. In recent amendment of Indian Patents Act, the appellate board has been abolished. Section 52, subsection 2. Where any such order is passed, the controller shall, on request by the petitioner made in prescribed manner, grant to him, number 1, in case where appellate board or court permits the whole of the patent to be granted, a new patent bearing same date and number as the patent revoked, or in case where appellate board or court permits part only of the patent to be granted, a new patent for such part bearing same date as the patent revoked and numbered in such manner as may be prescribed. Provided that the controller may, as a condition of such grant, require the petitioner to file a new and complete specification to the satisfaction of the controller, describing and claiming that part of the invention for which the patent is to be granted. Section 52, subsection 4. No suit shall be brought for any infringement of patent granted under this section committed before the actual date on which such patent was granted. Relevant rule is Rule 79. It says that a request under Section 52, subsection 2 shall be made in Form 12 within 3 months from the date in order of the appellate board or court referred to in subsection 1, and shall be accompanied by a statement setting out the facts upon which the petitioner relies and the relief he claims, and a certified copy of the order of the board or court. The board or court has ordered the grant of patent to the applicant only for a part of the invention. Then, in that case, the new patent granted shall be accorded a number in the same series of the numbers accorded to the complete specification accepted on the same day as the patent is granted. Now let's come to section 53, term of patent, subsection 1. The term of every patent which has not expired or not ceased to have effect on the date of such commencement shall be 20 years from the date of filing of the application for the patent. Subsection 2. A patent shall cease to have effect, notwithstanding anything therein or in this Act, on expiration of the period prescribed for the payment of renewal fee, if that fee is not paid within prescribed period or within such extended period as may be prescribed. Subsection 4. The subject matter covered by the patent shall not be entitled to any protection on cessation of patent right due to non-payment of renewal fee or on expiry of term of patent. Relevant rule is Rule 80. To keep a patent in force, renewal fee should be payable at the expiration of second year from the date of patent or any succeeding year, and the same shall be remitted to the patent office before the expiration of the second or the succeeding year. The period may be extended to such period not being more than 6 months if request for extension is made through Form 4 with fee. While paying renewal fee, number and date of the patent and year in respect of which the fee is paid should be quoted. The annual renewal fee payable in respect of 2 or more years may be paid in advance. The controller shall, after making such enquiry as he may deem necessary, credit any renewal fee and issue a certificate that the fee has been paid. The relevant form with the fee is shown here, which is related to the sections covered in this video. Thank you all for watching the video. Please give a like and please share and subscribe the channel Scientellectual. We are providing the necessary informations regarding Indian Patents Act section, rule, form and fees, which will be helpful during the preparation of Indian Patent Agent exam. Thank you all.